Hello everyone and welcome to this Legal 500 webinar in partnership with Olajide Oyewole LLP and DLA Piper Africa, practical guidance for international arbitration in Nigeria. My name is Joe Boswell. I'm a senior member of the Legal 500's in-house legal research team, and I'll be introducing and concluding today's session. We're very lucky to have an excellent panel here to discuss our topic for the next hour or so as they examine in detail some of the issues at the forefront of Nigeria's bustling arbitration scene. Tunde Oyewole is the country managing partner of Olajide Oyewole and boasts a wealth of experience in structured finance. He is a leading expert on technology and transfer projects and has been involved in individual transactions worth more than $3 billion US. Muyuya Ogunbenro is a partner and head of litigation at the firm, where he advises and represents clients in commercial cross-border litigation, shareholder disputes, and international trade disputes. He appears before both domestic and international commercial arbitration tribunals and has worked with a range of high-value clients, including Samsung Heavy Industries and Arcadia Group. This session is interactive, so if you have questions at any point during the webinar, please type these in the Q&A function, and we'll put these to the panel once the presentation's over. So I'd now like to throw over to Tunde, who is going to lead the discussion and start the presentation today.
Thank you very much. My name is Tunde Oyewole, and as Robert said, I'm the country managing partner for Olajide Oyewole, the DLA Piper firm in Nigeria. Now, we're going to talk primarily about issues, practical issues surrounding international arbitration in Nigeria. However, I'm going to talk more from the perspective of in-house general counsel who is managing a portfolio of arbitration matters from within the firm. My partner, Muyiwa, will talk from the perspective of external counsel. My qualification for speaking from the general counsel point of view is that I was general counsel for 5.5 years at V-Mobile Nigeria, which is now called Airtel Nigeria. And during my period, we had quite a lot of litigation and arbitration, quite a lot of disputes within the company that I had to manage. And a lot of them went through arbitration. So I'll be speaking from my experience in managing a portfolio of complex international arbitrations. Now, we're going to deal with the topic from three main headings. We're going to look at conditions precedent, we're going to look at appointments of arbitrators, we're going to look at costs of arbitration, we're going to look at interim relief, and then finally, we'll talk about evidence for the trial if the matter goes to trial. So, looking at the first issue, now any arbitration matter starts from the drafting of the arbitration agreement. And that's where a lot of arbitrations are actually decided, not when the dispute has started. And accordingly, as general counsel, when we're drafting contracts and looking at arbitration agreements, we need to look carefully at how the arbitration agreement itself is constructed. Now, there are different models for arbitration agreements, and particularly for complex transactions, we often see what we call a tiered arbitration clause or escalation provisions, whereby there are different levels of dispute resolution. And what you have is that in some cases, before you can go to arbitration, the contract requires you to go in for some structured negotiations. Usually, you have clauses that say principals of the two parties will come together to try and resolve disputes before the parties go to arbitration. Sometimes you have clauses that require you to go to mediation before you can commence legal proceedings. Now, increasingly, you also find, particularly when you look at the English CPR and in some jurisdictions, where the tribunal is authorized in some cases to require or suggest to parties to go for an early neutral evaluation of the merits, which is, and this is where you have a case where the parties will put together their preliminary points, have a neutral party look at it, give a non-binding adjudication on the issues, and which will help the parties clarify whether they want to proceed to trial on the merits. So those are things that help to reduce the costs of arbitration and to ensure that eventually when you get to the arbitration, you have narrowed the issues and you know what the real issues are. Because sometimes a lot of disputes are driven by emotional or other consideration rather than simple hard-headed economic logical considerations. So some of the most intractable disputes that I've come across has been because of a lot of bad blood between the parties, and one or the other of the parties are not being entirely rational. Secondly, when you're looking at an arbitration clause, you have to look at it from the point of view as to whether you are you're looking from it from a point of offense or a point of defense. And the considerations vary, because if I'm defending a matter, how I would approach it from a tactical point of view is different from if I were the claimant. And often you find out that the claimant is looking for a speedy resolution, while the defendant is often looking to drag out the proceedings, particularly where one party does not have a very strong case on the merits. So you need to look again carefully at your clauses to ensure that you are not held hostage to some of those clauses. So for instance, I've had a major arbitration that has been that has dragged out for several months because one of the parties is insisting that the other party did not go through the escalation provisions, whereas the party that caused the problem had put the other party in an untenable situation that if they went through the escalation provisions would have taken at least a month, by which time the injury would have been irreversible. So we need to be very, very careful how we draft our arbitration clauses. Now, another point that we sometimes look for as an alternative to arbitration, which is to have an expert determination which is binding on the parties. And that is often done in construction contracts where the issues would deal more with technical issues rather than points of law or other commercial points. So we need to look at all of those when we're drafting, because sometimes you might find that quite a number of contracts have come into matter that say certain disputes will be determined by expert adjudication, whereas certain types of disputes will go to arbitration. So all of those need to be carefully considered when we're drafting arbitration clauses. Now, the next thing that you should look at, both when you are drafting the arbitration agreement and also when you're looking at commencing arbitration, is to look at the number of arbitrators and what kind of arbitrators you want. The normal options are usually to have a single arbitrator or 3 arbitrators. Usually you have single arbitrators where the matter is relatively simple and not too complex. And you have 3 arbitrators where the matter is more complex, and you also want to avoid bias from a single arbitrator affecting the results. But you then have a problem often about how do you appoint arbitrators. Usually when you have a single arbitrator, the parties are supposed to agree to who that single arbitrator will be. But if they cannot agree, then you have to put in a mechanism as to who would appoint that arbitrator where the parties cannot agree. And sometimes you have an independent appointing body. Sometimes you say the ICC, president of the Institute of Arbitrators, and something like that. But where the parties don't agree, then and the agreement is silent, then you have to look at the rules or what the law says. And then another complication that we face is where there are more than 2 parties. Because usually the reason for the standard clause for 3 arbitrators assumes that there are 2 parties and that each party appoints 1 arbitrator, and then the 2 arbitrators will appoint an umpire. But where there are more than 2 parties, it then becomes more complicated. Who appoints the arbitrators? I've had a situation in which there were 21 parties. It was a shareholder dispute, and there were 21 different shareholders, each with his own agenda and his own interests. So we ended up having 5 different silks in the room. At the end of the day, obviously, they couldn't agree on appointing arbitrators. And then there was a dispute as to who had the power to appoint arbitrators, because the contract did not envisage who would appoint arbitrators if they couldn't agree. And in that case, it was a ancestral arbitration under Nigerian law. And then we had an interesting point of dispute. The ACA, that is the Arbitration and Conciliation Act, says that in the absence of agreement on arbitrators, the court shall appoint the arbitrators. But because the agreement said ancestral rules, one of the parties said, no, no, no. Under the ancestral rules, it is the Permanent Court of Arbitration in The Hague that should appoint it. And they went to The Hague, and The Hague said, yes, we have jurisdiction to appoint arbitrators. Went ahead and appointed arbitrators and said, oh, if you have an objection, raise it with the arbitrators. And we then raised the objection with the arbitrators, who said, oh, we'll hear everything together along with the objection. We went through trial, gave evidence, did everything. And at the end of the day, after 18 months, the tribunal ruled that they did not have jurisdiction because they were not properly appointed, as the PCA did not have the power under Nigerian law to appoint the arbitrators. So they had to go back to court to get the court to appoint arbitrators. So that's an extreme case, but it's just to show that when we're looking at drafting these clauses, we need to be careful and think about all the ramifications and potential scenarios. So, and then under Nigerian law, there's also an issue as to which is the appropriate court. Is it the Federal High Court or is it the State High Court? There are views in certain sides, and I share that opinion, that arbitration is a residual matter. It is not a federal matter. And therefore, it is the state courts that have the jurisdiction. And there have been conflicting rulings. I've had rulings at the Federal High Court where the judge has said, yes, we have jurisdiction. And I've also had in the State High Court where the State High Court has said, no, it's a state matter, and therefore the state court has jurisdiction. So these are things that one should really think about And then which kind of rules are we going to adopt? Are you going to adopt LCIA rules? Are you going to adopt ancestral rules? Are you going to adopt the rules in the schedule to the ACA? Are you going to adopt the Lagos State arbitration rules? There's so many options, and each of them has its own little nuance and implications for each. Personally, I prefer always the LCIA rules and London seated arbitration because for me, in terms of practical speed of proceedings, I think the LCIA and the London seat usually provide the quickest route and the most sure environment for arbitrations. But that's just me. Some other lawyers will have different opinions about that. So now, when we now get to the nitty-gritty of which arbitrators we want to appoint, we need to look at the different qualifications for the arbitrators. Now, there is the issue of, do we want the arbitrator to have subject matter knowledge? That is, if it's a construction contract, an engineering construction dispute, do you want the arbitrator to have personal knowledge of that subject matter? If it's a maritime matter, do you want an arbitrator who is experienced in that matter? Or are you going to rely on the parties adducing expert evidence such that the arbitrators do not need to have the subject matter? Then we're talking about procedural experience, and I find that this is something that is very, very important that is often overlooked. Where you have complex arbitrations where some of the parties want to take procedural issues to delay the arbitration, we find out that where the arbitrators do not have sufficient experience, they can easily be sidetracked by counsel who are determined to use procedural objections in order to stall or delay the hearing of the arbitration. Then also looking at, when we're choosing the arbitrators, we want to know that, does this arbitrator have previous experience in this particular area or this environment? So for instance, we were having arbitrations involving Nigerian parties. Does it help to have an arbitrator who understands the African business environment as opposed to somebody who is coming from purely European environment and who doesn't understand the nuances of the Nigerian business climate? So those are the kind of things that we're looking at in appointing arbitrators. So different kinds of experience, different kinds of knowledge, and all depends on what is the actual issue and dispute in that, particularly in that dispute. So sometimes it's purely legal points of law or general commercial points of law, but sometimes there are complex technical issues that need to be considered. And if the arbitrator is struggling to understand those concepts, then there's a possibility that it can lead to errors. So let me just stop there because I know I can go on and on about these things. So we're going to cost of arbitration, and I'll ask Muyiwa to come in here because this is really where the rubber hits the road, because when you're looking at the cost of arbitration, that's the real meat of the issue. So Muyiwa, please, over to you.
Thank you very much, Mr. Oli, for your presentation. And as you said, this is the point where parties get to determine whether to proceed the arbitration or whether they will have to retract and go back to the court. And with all the things that Mr. Wally has mentioned, you've considered the number of arbitrators that you want to appoint, how you're going to appoint them, and all that. Then the next issue that you have to consider is the cost of the arbitration itself. Like we all know, arbitration is much more expensive than normal litigation in court. It has its advantages, but at the same time, you have to weigh the opportunity, the money that you have to put down to get that advantage. Now, the number one thing that you have to consider is the arbitrator's fee. Now, for arbitrations that are institutional arbitration, that are rules or that are scale of charges that have been agreed within that institution to be charged by the arbitrators appointed under that arbitration. So you don't have a lot of room to negotiate their fees. It's already fixed, and they are usually they've considered what the claims are like or amount involved in arriving at the figure. So it's just a matter of looking at those scales and agreeing whether you want to proceed with the arbitration or not. Then the other one is where you have ad hoc arbitration. So in those situations, you are the one, or the parties are the one controlling the administration of the arbitration itself. So you are the one in charge. So you have to negotiate directly with, or agree directly with the arbitrators on what their fees will look like. And this is where they get to tell you how much they're going to charge. And my recent experience is that this can be really, really high, depending on the amount of claim involved. Where you are claiming millions of dollars, you should expect that they will also look into this in assessing their fees. So this is something that we really need to put into consideration, especially when we are drafting arbitration clauses. I've seen situations where parties agreed 3 arbitrators in a contract without any qualification. So if there's any dispute at all, it has to be 3 arbitrators. And the issue that then came out of it might be something that is so small, or that you don't need that number of arbitrators to decide. But at the same time, if you have to resolve any dispute at all, you have to appoint 3 arbitrators. And appointing 3 arbitrators, like we said, is a major factor that would drive how much you have to put down to pursue the arbitration. Another factor that can drive the cost of your arbitration is at the end of the day, there might be a number of interlocutory applications that the tribunal will have to consider, and they're probably charging their fees per hour. So all of those things will contribute to how much you have to pay for the arbitration. Then usually, whether you are doing institutional arbitration or ad hoc arbitration, you have to pay deposit to the institution, or you are the one incurring the cost as you go along. You have to pay deposits to move the arbitration forward. And one factor that you have to consider in that situation is if you have an arbitration where the respondent probably has a view that, oh, I don't have a good case, or I'm just not interested in this arbitration, and is not participating in the arbitration, then you will have to pull down all of the costs. So you have to bear the cost more or less. You have to carry the respondent probably until the end of the arbitration when you have your award, and then you can have costs award in your favor. So this is something that you have to consider right from the beginning. Is it likely that the respondent will participate? If he's not going to participate, you have to bear in mind that you might have to carry that respondent until you have your cost award. Then you also have to consider the expert fees for the lawyers. It could be fixed, and it could be on hourly basis. And like I said, if you have a number of interlocutory applications, or depending on the complexity of the arbitration itself, of the dispute, then that will then determine how much of hours your counsel will clock, and then how much you have to pay at the end of to get your award. Now, in looking at these, you have to focus your attention on your litigation cost and how much you are claiming from the other party as well. So you have to make that economic decision whether it was pursuing or not. Then there are other ancillary costs like transcription costs and transport. If the arbitration is going to take place, say for example in London, moving witnesses, moving experts from Nigeria to London, you have to consider all of those costs as well. Then, like I said, at the end of the award, that's when you are hoping to recover your costs, either as claimant or as the respondent. So the claimants, if you win, then you most likely get cost award in your favor. But it doesn't mean that all of your costs will be passed on to the respondent. The arbitral tribunal has the discretion on how they are going to apportion the cost. It might well be that there are certain applications that you have made in the course of the arbitration and you have lost. The tribunal may not want to put that cost to the respondent. So at the end of the award, you have your award of costs, which might then be in your favor. Can we move on to the next slide? So in the course of, while you are still considering how you are going to move on with your arbitration, one thing that I've found to be very, very important that parties look for these days is interim injunctions. You have a party or the respondent or the potential respondent that you know for sure will take certain steps if you don't get an injunction. So the issue is whether you should apply for an injunction before the arbitral tribunal itself, or you should go to court to go and get that injunction. So most rules of arbitration now, allows for the arbitral tribunal itself to award interim measures, just like you have in court. So that will be the first thing that you have to deal with when they are appointed. But don't forget that you can make such an application until the arbitral tribunal itself has been constituted. So the whole will have to be appointed. Now, if you look at the provisions under either the Arbitration and Conciliation Act or under the Lagos State law of arbitration, Lagos State arbitration law, or even under the LCIA rules and other institutional arbitration rules, there are a number of days within which a party has to appoint his or arbitrator. Now, for example, under the Arbitration and Conciliation Act, you have 30 days for the defendant to appoint his own arbitrator. So 30 days is a long time when you need interim measures. So then you have to consider whether it's something that you have to wait until the arbitral tribunal is fully formed before you can then make an application for interim measure. Now, after that, you have to consider the enforcement of the arbitration award itself. There seems to be a controversy as to whether interim measures are enforceable like final award. In my own opinion, I think the Arbitration and Conciliation Act and the Arbitration Law of Lagos State both allow for enforcement of interim measures. Especially under the Arbitration and Conciliation Act, it didn't specify whether an award that is interim cannot be enforced. So I would take it that you can also enforce interim measures as the final award. So you have to consider those factors. And you also need to consider whether you are going to use the court to enforce the interim measure. So if you're going to do that, that would then mean that after the tribunal has given you the award and the interim measure, then you have to apply to the court for enforcement. And another way that you might want to look at it is you might just want to allow the tribunal to enforce its own award. You ask me, how will the tribunal enforce its own award? Yes, they don't have the power to commit anybody to prison like we have in court, so you can say content of the tribunal before the same tribunal. But what we may then want to do is, if a party is not willing to obey an interim measure, that same party will still need to convince the same tribunal to rule in its favor. So in that situation, you are more or less pushing that respondent to continue with the arbitration where they themselves are not obeying interim measure that has been issued by the same award. So most people, just for the sake of getting the tribunal on their side, will obey the interim measure and then move on with the arbitration. But it's not out of this world to have a party who is willing to just disobey the tribunal and then move on with the proceedings. Now, the other one that you also have to consider is whether you are going before the court to get your interim measures. Now, like Mr. Iwali said, the issue is which court are you going to? In Lagos, are you going to go before the Federal High Court, or are you going to go before the State High Court? Now, for State High Courts, you have the Arbitration Law of Lagos State 2009, which makes a lot of provision empowering the court to give interim measures in aid of arbitration. And when we are talking about court in this context, we are not talking about you filing your substantive claim before the court. You are only filing an application, like an originating motion before the court, asking for relief to support your arbitration. So for state courts, there's a law of provision under the arbitration law that empowers them to do that. But for the Federal High Court, where the parties have adopted the Arbitration and Conciliation Act, the provision is not so clear as to whether the court has the power to grant interim measures. But that are bits and pieces here that you can put together to say that the courts and the Federal High Court has jurisdiction to grant interim measures. One of them is that the court ordinarily has the power to grant injunctions where the court has deemed fit. So you can rely on that. And then under the arbitration rules that we have under the LCIA, there's also a provision there where the courts, where the law allows the courts, where you can seek interim measure before the tribunal, and at the same time, the Article 26.3 says a request for interim measures addressed by any party to court shall not be deemed incompatible with the agreement to arbitrate or as a waiver of the agreement. So there's a bit and pieces that you can put together there to say that Federal High Court has the power to award interim measures. I think I will have to stop there for Mr. Wali to then continue with the rest of the presentation.
Okay, so let me just come in at this point. I'll just talk a little bit about document management, particularly when we are going on to trial. That's assuming we've gone through all the preliminary issues and we are now about to go to trial. Now, the critical thing is getting all the evidence together. And nowadays, for arbitrations, most of the evidence will be in the form of documentary evidence. You'll have your witness statements and you'll have supporting exhibits. Now, one of the key things that a lot of practitioners stumble upon is the requirement for document production. It's in the rules, both the Nigerian rules and in the international rules like the LCIA rules and ICC rules, but a lot of practitioners do not understand their obligations under the document production rules, and which is that you must produce every document in your possession relating to the dispute. And a lot of clients do not, either don't keep proper records, or where they keep proper records, they do not disclose those documents. And sometimes you get to trial and suddenly find out that, oh, there was a document that your client should have produced. It was your client's custody and the client never did produce it. So the first thing we have to do as a legal practitioner is sit with the client first to ensure that you have all the documents. Even if you are not going to produce them to the other side, you as a counsel must first ensure that you have all documents collated and analyzed. And then all the correspondence, emails, everything has to be gathered in together. Then we need to analyze those documents and determine those that are relevant. And then amongst the relevant documents, you then need to determine which ones are confidential, which ones are privileged, and which ones you can disclose to the other parties. And then usually you'll have to exchange document lists. Now, for complex commercial disputes, sometimes these documents can run into thousands of pages. I remember one major arbitration I did in London where we had the bundle of documents was 85 ACK liver files. And it meant that all those documents needed to be cataloged, indexed, analyzed, and somebody needed to read every document to ensure that there are no surprises. So there's nothing, you cannot avoid doing that hard work. This is where a lot of practitioners sometimes try to cut corners because, and even the clients, because when the client is looking at the cost and say, oh, I don't want to, why am I spending so many hours just reading documents? So you try and minimize it, but if you don't go through all the documents, then you run the risk of a major surprise coming up at the trial. And then it's only after you have gone through all the documents and you understand all the issues that you can actually start to draft the pleadings. And this is usually areas that need to be very, very critically done. You can't just do it in a rush. It can take several months to ensure that you have all the facts, all the relevant facts, and all the issues done right up front. Because one of the things that can easily derail a trial is finding out that at a late stage of the trial, you suddenly find out some new facts, and you have to start applying to amend pleadings at a late stage. And I know that most tribunals frown heavily on that because one of the things about arbitration is you tend to have a fixed, tight schedule, and anything that changes that schedule means you're having delays, because you always remember that most arbitrators, this is not their full-time job. They have other things to do. So they now have to look at their own calendars. And when you have 3 arbitrators, you have to reconcile availability for 3 different busy barristers or judges or whoever they are. So, but one of the things is that technology has made a big difference, because now you can have documents scanned, simply looking for keywords, and then only those that have those documents that contain the relevant keywords are those that then need to be manually reviewed by counsel. So with the current, I think the last couple of years, particularly with the pandemic, with everything moving electronic, we're dealing less and less with physical documents and more with electronic documents. We're finding out that technology is gradually coming into the fore with arbitration practice. And so what we are finding out is that a lot of this, how do I say it, the drudge work and the routine things can now be done through machine learning and similar things, but it still must be done. That's the critical thing. We cannot cut corners and not do it. So whether you're doing it manually or you're doing it with the aid of technology, it is a very critical step to trial. And this is where I would say most trials are won and lost. It is not the brilliance of counsel's arguments or closing submissions. It is the nitty-gritty of going through all the documents and evidence and presenting a clear, concise case for the arbitrators to look at. So I think let's stop there and then maybe take questions or comments from participants, or if the moderator wants to maybe kick off with some questions.
Yeah, I suppose first of all, one of the questions I wanted to ask was about Nigeria as an arbitration center or a regional arbitration center, and how you rank it compared to some other places where you've conducted arbitrations or been involved in them, and where you think the country might want to go next in terms of conducting arbitrations within the country.
Okay, thank you. I think Nigeria definitely has strong ambitions to become a regional arbitration center, and particularly the reforms by Lagos State was actually driven by that desire. And what they've done is they've tried to model the Lagos State law and the Lagos State ecosystem on the London Court of International Arbitration. So Lagos State set up an arbitration center and set up a Lagos Court of Arbitration, everything modeled on the LCIA, and the law also has borrowed a lot from the English jurisprudence, and a lot of decided cases to say what really do arbitrators want, or participants who are looking for arbitration, what do they want? So we have the institutional framework already in place, but what it needs is for confidence from users, and that will take some time, that once people get comfortable that yes, the institutional framework is robust enough, and that we definitely have sufficient knowledgeable practitioners to support arbitration as a regional arbitration center. So I think we are going that route, and we will get there over time.
We got a question here. How do I deal with drafting of arbitration clauses for a complex multi-party contract where there are no more than 3 arbitrators preferred by all the parties?
Yes, I think, like I said, for that kind of situation where you have multi-party arbitration, but you want 3 parties. So what you need to do is most likely you will need to have an independent appointing authority, and there are different appointing bodies. A very popular one is the president of the Chartered Institute of Arbitrators, is often mentioned in a lot of contracts. But alternatives include the ICC and the LCIA, because all those bodies have lists of arbitrators that they can call upon, and they look at the nature of the dispute and they can easily match an arbitrator with the relevant expertise and experience. So what you really need to consider in that case is who should be your appointing authority, and you have a lot of choices.
If I may just add to what Mr. Wale said, when it comes to multi-party arbitration, first of all, the disputes most of the time can be easily divided into two. So where you have the claimant, the group of claimants on one side, and then the group of defendants on one side. So it might well be possible that you are able to reach an agreement on the appointment that way. Then if you're unable to reach an appointment, like Mr. Iwale said, you fall back to the default provision, either under the Arbitration Act or under the Arbitration Law of Lagos State, which then specify where parties are unable to appoint arbitrators, where do you go? So depending on which law you are looking at, it could be the president of the Chartered Institute of Arbitrator, or it could be that you are going back to the court, as we have under the Arbitration and Conciliation Act.
Thanks very much. Got a question here about how the pandemic has impacted how you have conducted disputes in Nigeria, and virtual hearings and things like that. Yeah, any comments on some of the interesting developments that the pandemic has caused you?
Okay, if I may answer that question, I would say that even before the pandemic, arbitration has been ahead of litigation, either in Nigeria or even abroad. So in terms of adapting to technology, arbitration is much more easy, and they are moving ahead. So with the heat of the pandemic, arbitration has continued unhindered. There have been a number of arbitration proceedings that have gone on purely online, without having to travel to anywhere. And so arbitration has really gone ahead of litigation and is moving on without any hitch.
Cool. I've got a question for Tunde here. Can you talk some more about the practicalities of mobilizing a team to basically start with doing what you need to do to conduct an arbitration, locating documents, selecting and analyzing the potentially relevant ones?
Yes. Now, what I find that the first point of call has to be the client. The client needs to set up dedicated team whose job is to do that in-house. External lawyers can come in and start going through mailboxes or file folders to search for documents. So what we do in practice is that we will usually, as counsel, first provide a suggested list of documents that they should search for. But the client then needs to have somebody in-house who would be primarily responsible. Now, there are two ways of doing it. One is for the client to drive the process internally. That is, the client sets up a small team in-house and somebody in-house leads that team. But that's where the in-house team understand what they need to do. So usually if you have a strong in-house legal department, then the in-house legal department can lead that process. But where you don't have any strong internal legal team, then what we've done in the past is to have the law firm like second one or two people to sit in the client's premises and then help them, guide them, and help them sift through the documents to select the relevant document. But it's not a one size fits all. Everything depends on the context of the case and also the relevant relative sophistication of the client. There are some clients that have internal electronic document management systems, so they can simply do everything. The IT department can do everything for you, which has happened for one of our major clients. Didn't require us to talk to anybody, just talk to the IT, give them the keywords, and they were able to search through emails, search through files that were on the computers throughout the whole organization. But everything depends on how the client stores their documents. If the client stores their documents in physical folders and files, then you don't have any choice, but you must go and sit down in the office to go through those files. So I don't know if that helps.
Thanks very much. Got a sort of technical question here. Does the preference for LCIA rules and London-seated arbitration still apply even when the parties are domiciled in Nigeria, the transaction is domiciled in Nigeria, and the contract is governed by Nigerian law? And what are some of the practical considerations for this preference?
Okay, first and foremost, what you mentioned is a purely domestic arbitration, which is where all the parties are all Nigerian, the contract is Nigerian law, and so on. So in that case, obviously, you would seek, the seat of arbitration would be logically in Nigeria, and you would want, you rely on Nigeria. So what you're looking at is in such cases, the consideration would be which jurisdiction locally, do I want to go to federal or do I want state? And in that case, I would obviously go for the Lagos State arbitration law and Lagos State arbitration rules, because they're purely domestic arbitration. But my reference to LCIA rules was in the context that we were discussing international arbitrations, where you have one or more parties are not Nigerian. So in that case, preference would be LCIA rules, English seated, even if the contract is under Nigerian law. We've done a number of arbitrations where the contract is Nigerian law, but the parties are not non-Nigerian. And in such cases, we had Nigerian law, but English-seated arbitration under the law of the arbitration was English, the procedural law of the arbitration was English law, but the substantive contract was Nigerian law.
Thanks for clearing that up. Another question here. During the presentation, it was mentioned that where a party fails to adhere to an interim measure, this may affect the arbitrator's decision at the final award stage, which appears to show that you could have a scenario where the conduct of the parties may taint the decision of the arbitrators. Is this not against their obligation to be fair and unbiased?
Okay. Yes, the arbitrators have obligation to be fair and unbiased, but at the same time, we should not forget that when you are before the arbitrators, you are looking at the historical incident, what happened, and all of those things, and then the arbitrators will start to infer how you do business. Are you likely to have done these and all of those things? So those are the factors that the arbitrators will be looking out for. And if you are before an arbitrator that has issued an interim measure, which you have disobeyed, the chances are that it gives them an impression of the way you do business as well. And it is easier for them to conclude against you than to make a decision in your favor. That's what that is all about. At the end of the day, they have the decision to make on what is fair and what they think is right. So it's all about you being able to convince the arbitrators of your position when you are in disobedience of their order.
Thanks very much. Got another question here. One of the key advantages of arbitration over litigation historically was turnaround time. But nowadays, it appears that this might not necessarily be the case, given the trend of a number of arbitrations, which have gone on for a long time, basically. How do you advise parties mitigate this potential issue and improve confidence in alternative dispute resolution altogether?
Okay. Yes, one of the selling points of arbitration is the turnaround time, but the way is every step is being challenged, then called into question that objective. Now, but what you still have to bear in mind is, for example, where you have three arbitrators, three-member arbitrators who are deciding on a point, the chances are that you will, depending on the complexity of the case, you make a better case before the arbitrators than before the court, a single judge sitting on your matter. And so that's still a selling point for arbitration. And another thing that you also have to consider is there are grounds for setting aside arbitration award, but many of them are really, really difficult to prove. So once you have your award on merit from the arbitral tribunal, then you are putting the other side on a very difficult position to overturn that award. And if you look at the trend these days, the judges are more inclined of maintaining the arbitration award than setting it aside. So yes, you lose some time with the way they fight challenges and all that. But if you are able to get your award, I think you are still in a better position compared to when you go straight before the court. And it also depends on the complexity of the dispute.
Sorry, I was on mute. We're going to be wrapping up reasonably shortly, so I thought I'd end on more of a general question. So we've got a question here, which is, what are some of the ways that parties can get the most out of an arbitration? So some things that anyone looking to be involved in arbitration can do to get everything in order to get the most out of the process.
I think it all depends on where you belong. If you are the claimant, you are probably, you feel so strong about your case, and you, of course, more than 50-50 chance sure of your position. So in that case, you want to go all out to get the arbitration award in your favor. So you have to maximize the process by making sure that you don't lose anything to as a result of a procedural step, or missing any issue that you should have properly addressed, and making sure that you present a really good case. So for me, that's one way to make sure that you maximize the opportunities coming from the arbitration. But if you are on the other side, or if your case is not that strong anyway, you might then want to consider, should I go to court first and wait for the other party to to pick up an issue and say, oh, we have arbitration clause in the agreement. And then you test the water that way, making sure that you don't waste a whole lot of money pursuing arbitration and then coming back with something that doesn't worth it. So you might want to look at approaching the court and see what you can get with that. And for the a respondent is also about the same thing. And I've seen a number of situations where after a claimant has raised an issue, the respondent then say, oh, right, I also have a counterclaim. And then the counterclaim then turning out to overweigh the original claim itself. So the defendant in that circumstance has maximized the arbitration opportunity to use, and using it for his own favor. But at the same time, you might also be in a position where you don't think you have a good case fighting the arbitration. And then at the end of the day, you still have to pay the winning party's cost. You may then want to just assess your costs and the likely damages and see whether you will be better off settling those kind of potential liability before each cost is incurred against you. So those are the ways that I think you can maximize your arbitration.
Thanks very much. Did you have anything to add today, or
I think just to add that, as to stress a bit what we mentioned, which is preparation is critical to maximizing the benefits. If you are not well prepared, then you lose a lot of the benefits. So taking time to go through everything sequentially and properly would ensure that you get the best benefits from the arbitration.
Perfect. Well, thanks a lot, everyone. We're about on time to end there. So just time to say thank you very much to everyone for showing up and watching and sending such good questions in for the Q&A session. And thanks most of all to our two fantastic panelists, Tunde and Miua, for such an interesting presentation. Just to remind you, we'll be uploading this whole session on our website over the next few days. So if you want to rewatch anything, then you can go on the link I shared in the chat just now to look back over everything. And I suppose I'll just sign off by saying thanks very much to everyone involved, especially our sponsors, Olajide Oyewole LLP and DLA Piper Africa. This has been a Legal 500 webinar, and see you all again next time. Thank you very much.
Thank you.
Thank you.
Thanks.
Bye.